afternoon, and thank you for joining today's webinar, How to Prevent and Respond to Harassment and Bullying. My name is Isa Hackett. I am an employee of Redback Conferencing and your facilitator for today's session. Today's webinar is all about you and your workplace and how to keep it free from discrimination, harassment, and bullying. Before we get started, some housekeeping rules for newcomers. Today's webinar will be in listen-only mode, which means that if you do wish to ask a question to either the presenter or myself, please use the text chat functionality. This is located in the bottom left corner of your screen. And if you experience any issues in hearing the sound coming from your computer, please feel free to listen to the webinar through your telephone. To do this, simply dial the toll-free 1-800 number provided in the message box, and when prompted, enter the passcode provided. Please also note that the webinar will be recorded and you will receive a copy of this along with the presentation slides. Now, I would like to introduce Paul Maguire. Paul is the Director of Maguire Consulting and the owner of Employee Relations Online. He is engaged in human services, health, retail and IT, to name a few, and works with small to medium enterprises throughout Australia. So without any further ado, I would now like to pass it over to Paul. How are you today, Paul?
Good, thank you, Isa, and thanks for introducing me. Well, welcome everyone. This subject that I'm covering today is undoubtedly one of the most challenging areas for human resource managers, small business owners, and anyone performing the employer's function. This will necessarily be an overview of the subject, but I trust you'll be able to take out of today's webinar sufficient information to give you confidence that you can actually address this in a reasonably competent manner. If you're wanting to contact me, then I've provided some details in the next slide, which is with the web address and email address. So you'll see there. So if at the conclusion of this you had any questions or you wanted a discussion, then I'm happy to talk to you, no obligation. Anyway, let's get started. In relation to the topic of preventing and responding to workplace bullying and harassment, I want to outline your responsibilities as employers under equal opportunity laws, anti-discrimination and bullying laws. Also discuss the sources of workplace conflict and some effective strategies to prevent bullying and harassment. Thirdly, explain the importance of workplace policies and procedures when responding to grievances of this nature. And then finally, hopefully I can provide you with some useful tips in addressing this very challenging responsibility. All right, let's start off with a poll. Who has personally experienced bullying or harassment at work? We'll pause to see. Okay, well, that's some interesting figures. 78% have said yes. Okay. Now, what about a second question? Who has witnessed bullying or harassment at work? Let's take a poll on that. Okay, once again, it's 86%. That's a lot of people who've witnessed it, and it's certainly a lot of people who have experienced it personally. What I want to firstly talk about is how big is the problem across Australia. Data on workplace bullying and harassment is not yet collected in sufficient numbers or quality to really quantify accurately the extent of the problem. For example, the Australian Bureau of Statistics, in its work-related injury survey in 2009-10, showed that workers or employees who reported mental stress, of which bullying and harassment is a subcategory, were less likely to claim workers' compensation than workers with other injuries. In fact, 70% of workers who reported they experienced work-related stress didn't apply for workers' compensation. Nevertheless, the incidence of accepted workers' compensation claims does in fact provide us with a useful indication of the problem for Australian employers. Safe Work Australia has conducted its own research, and it's reported on the incidence of accepted workers' compensation claims for mental stress in Australia, published in April 2013. This report aimed to explain what mental stress is, what causes it, and how it can affect the health and well-being of workers. An analysis of workers' compensation claims data shows the incidence of mental stress, including an analysis of the incidence, time lost from work, and the costs for each of the subcategories of mental stress. And as I just said, one such subcategory is work-related harassment and/or workplace bullying. The definition that they provided for this subcategory was repetitive assault and/or threatened assault by a work colleague or colleagues, and repetitive verbal harassment, threats, and abuse from a work colleague or colleagues. Now, some of the findings there are interesting. Mental stress claims are the most expensive form of workers' compensation claims because of the often lengthy periods of absence from work typical of these claims. And women were around 3 times more likely than men to make a workers' compensation claim due to work-related harassment and/or bullying. If we put this in context, you see from this chart that mental stress as what they call a mechanism, or really a cause of work-related compensation claims, mental stress constituted 3.4% of all claims across Australia. So it is quite small in that particular context. Of the mental stress claims, work-related harassment and workplace bullying was cited as the basis of mental stress claims, 22% of successful cases. That constitutes 0.75% of all successful claims across Australia over that survey period. However, as I indicated earlier, it should be noted that although low in comparison to the total number of claims for compensation, it's clearly underreported, and it is generally accepted that the incidence of bullying and harassment has a real impact on the well-being of individuals. The cost of workplace bullying and harassment. Notwithstanding the limitations of the data, there are some interesting indicators from the WorkSafe Australia report that will assist us to understand the impact and the costs where there is a workplace harassment and bullying. In turn, this should enable us to apply well-founded policies to address the risks and improve outcomes for employees and your businesses. For example, in 2009-10, the midpoint for the period of time that employees had off work for mental stress claims, 8.6 weeks. And that's a fair amount of time in anyone's business, whether small, medium or large. The median midpoint for direct cost of successful claims, inclusive of such things as medical expenses, taking into account the length of absence from work and the employee's pre-injury salary, it costs $16,400. And again, that's not an insubstantial amount or cost to you as employers. Now, if we get a handle on what the size of the problem is and the likely cost and impact on employers, well, we need to talk about what is bullying and harassment. Bullying as a phrase is very fashionable at the moment, and it's used to describe all sorts of behaviour in the workplace. However, as employers, it is a very, very difficult task to prevent something or respond to it if it's ill-defined. Bullying is not actually defined in any law in Australia. Well, not yet. As we'll talk about shortly, the current Australian government has plans to empower the Fair Work Commission to in fact deal with disputes or claims of bullying, and will be defining it in amendments to legislation. However, at the moment, it's simply a word of art which is used to describe a variety of behaviours that occurs in the workplace. Therefore, it's become the subject of considerable attention by Australian regulatory authorities. Two definitions developed by the Victorian Work Cover Authority and reflected in other states, and the Human Rights and Equal Opportunity Commission are on the slide. As you see, phrases such as repeated unreasonable behaviour, workplace bullying is verbal, physical, social or psychological abuse by an employer or manager or other person or group of people at work. Because the definitions are not precise, that is, phrases such as unreasonable behaviour and abuse are not defined in these broad definitions, then we need to look at the examples, something to describe what is bullying and harassment. Well, here's some of the definitions or descriptions that have come from the regulatory authorities in their own publications. For example, bullying is described as excluding or isolating employees from team activities, ridicule, insults, belittling opinions, nicknames, offensive language, yelling, screaming, verbal abuse, rudeness. Also assigning meaningless tasks unrelated to your job, giving employees impossible assignments, changing work rosters to inconvenience particular employees or withholding information. The Human Rights Commission provides even more graphic examples, and I ask you or invite you to go onto their websites if you haven't already and download the publications to look at those examples. Okay, harassment. Well, harassment is largely defined in federal anti-discrimination laws. In particular, it's described as behaviour that is not wanted, not asked for, and not returned, that is likely to offend, humiliate, or intimidate a person in your workplace. Harassment is usually talked about in the context of sexual harassment, that is, any unwelcome sexual behaviour which is likely to offend, humiliate, or intimidate. It could also be discriminatory, where it is directed at a person because they have attributes protected by the law. Interesting enough, and I think important to note, is that the resolution of bullying and harassment claims, if they're made and dealt with by a Human Rights Commission or an anti-discrimination tribunal or WorkSafe agencies or the Fair Work Commission, will seek to resolve these complaints using different tests because they have different sets of legislative basis on which to deal with the concept of harassment and bullying. For the purposes of this webinar, though, I'll use the phrase bullying and harassment interchangeably, as there is considerable overlap in the circumstances, the types of behaviour whereby this could give rise to a grievance in your own workplace. Now, I mentioned this just before. The Australian Government has proposed an amendment to the Fair Work Act aimed at empowering the Fair Work Commission to conciliate complaints of bullying. Although the amendment has not been passed by the Australian Parliament, if it is passed, and certainly news as recent as this morning that the Senate subcommittee have effectively approved it and recommending it being passed by the Parliament, then it's due to commence on the 1st of July this year. So we do need to get ready for it. If it is passed, then the Fair Work Commission will join the Human Rights and Equal Opportunity Commission and state-based anti-discrimination tribunals and state-based WorkSafe authorities as agencies able to receive and respond to complaints of workplace bullying and harassment. Fair Work Commission will not be taking over this exclusively. People that you employ and that you work with will be able to shop around to agencies to have their complaints dealt with under the heading of bullying and harassment. Now, the amendment under the Fair Work Act will enable the Fair Work Commission to order unspecified remedies. What they've indicated in the proposed amendment is that the remedies would be appropriate to prevent such conduct from recurring. And the Fair Work Commission could impose penalties on employers should it be satisfied that a person has been subjected to workplace bullying. One of the measures that the Commission would have power would be to require the employee's employer to do or not to do certain things to resolve the bullying complaint. So that's called specific performance. They could tell you as employers what you need to do in order to stop the bullying occurring again, or recurring as they've referred to. A failure to comply with an order of the Commission will be a civil penalty offence, and employers may be liable for a fine up to $33,000. Now, on the positive side, the proposed amendment to the Fair Work Act indicates that bullying would not include reasonable management practices, including performance management conducted in a reasonable manner. But does this really make it any clearer for employers? As you'll see from this slide, there is a lot of grey in the definitions that are provided by these regulatory authorities and as proposed under the Fair Work Act. When you compare the examples of bullying provided by some of these agencies with the additional statement in the Fair Work Amendment and also statements of what is supposed to constitute or is not supposed to constitute bullying and harassment, you'll see that there is a lot of grey and ambiguity. There is a very fine line. This is something that all employers will need to be very careful about, as this fine line between good and bad behaviour, bullying and harassment behaviour, and behaviour that is not considered bullying and harassment has the potential to engulf you as employers and as managers in unwarranted and quite costly debates, and it would seem litigation about performance, organisational change measures, performance appraisals, all those sorts of functions that you would normally undertake as part of running your business. You should, if I can give a tip this early on, you should note that these grey areas, note them all, and spend time in, if you're training and inducting your colleagues, managers and staff, in developing the management style and communication to enable them to perform the functions in a way so that what they are doing, for example, is not, if I highlight one section of it, the start, unjustified criticism or complaints, well, we want it to be constructive feedback, not unjustified criticisms and complaints. And as you'll see, there's very clearly a fine line with that sort of practice. If you can train your staff in that manner, then you'll have gone a long way to assisting yourself in dealing with this issue. What I do suggest is you can go to these particular websites and download the information that's provided there. You can do that at your leisure. Now, if I move on to sources of conflict and prevention methods, effectively understanding the underlying causes of conflict that develop into bullying and harassment complaints. In order for us to address the risks of employees suffering an injury, illness, an episode due to workplace bullying and harassment and incurring the costs and the time off work that we've highlighted earlier on, we need to understand the underlying causes. The old cliche, prevention is better than cure, is certainly pertinent to this issue. So ideally, we should address the primary causes, that is, eliminate the source wherever possible. Okay, let's identify the risk factors. Conflict that develops into bullying and harassment may occur for many and varied reasons. Let's categorise some reasons under two themes or two headings. Firstly, personal factors will play a role. How about at this stage, let's take a poll on the personal factors, and what I'd ask you to do is to, what personal factors listed on this slide are most likely to lead to bullying and harassment? You can select more than one. Let's start that now. Okay, let's see, things are moving forwards and backwards here. Let's have a look. We'll stop that one now and have a look. Okay, personality clashes. That doesn't surprise me. That's really interesting. Personal problems, e.g. divorce, gambling and so forth is there. But certainly personality clashes does seem to be an area which is a real risk factor. All right, secondly, we'll take another poll. Let's vote on management-related factors this time, and the question is, what management factors listed on this slide are most likely to lead to bullying and harassment? Okay, workplace culture was coming in late there to come in first at 86%. That's interesting. But immediately behind that, behaviour of the boss. Again, doesn't surprise me at all. That seems to be common themes borne out by this instant poll that certainly I've experienced with my clients throughout Australia, that they are the key risk factors. Okay, now, strategies to prevent workplace bullying and harassment will necessarily focus on these risk factors. And I found an interesting quote from the WorkSafe Australia report that I quoted, that I referred to earlier. And if I could just quote from what they've had to say, because I think it's really good advice. And it's in fact quite refreshing that the report is in fact quite honest and upfront about this. Mental stress, it refers to, is a significant issue for employees. Well, we know that, employers and the broader economy, and should be dealt with at an organisational level as well as at an individual level. Many organisations focus on helping individuals cope better with stress rather than dealing with the source of job stresses. However, research has shown that helping employees learn stress coping techniques may only have short-term success. It is not a long-term solution. The better option is to reduce the sources of workplace stress at an organisational level. This has been shown to have long-term benefits for the employees and the organisation as a whole. However, the most comprehensive stress intervention is best done on three levels. That is the primary, that's at the source. Secondly, controlling the hazards or the risk. And thirdly, is about treating the illness, treating the effects of it. One of the things that immediately leaps to mind in all of this, of course, is that if you are seeking to eliminate the source of the problem, if we're claiming the boss, the behaviour of the boss is one of the highest risk factors, then we've clearly got a problem which we're going to have to involve our bosses in, because eliminating the boss may not necessarily be a strategy that you have immediately available to you. But there are other ways of dealing with it, which we will get onto. And that leads the segue to reducing the risks. Once we know the risk factors that are most likely to lead to bullying and harassment, then we can design our workplace strategies to address these and reduce the risk of them developing into conflict. For example, we can apply some simple strategies: honest and regular communication, defining, making clear the expectations of performance, being alert to some of the key symptoms of a problem, and that is, for example, high absenteeism rates, high turnover rates among staff, applying a strategy of seeking honest and open feedback from the way in which you gather reports from staff, from your peers, and from superiors. reflecting on yourself. Try to see yourself from your staff's perspective. Treat staff equally. Avoid perceived favouritism. Proactively address rumours and rumblings, because there's often they are more than that. They are the kernel of some truth that's going on in the workplace. Learn from your peers. You don't necessarily need to learn it all yourself or know it all yourself. You can exchange ideas, consider strategies, and see what works. Watch out for staff experiencing personal or mental health issues. This is one of the big issues in Australian workplaces today. People don't leave their lives at the door anymore. You as employers, and I'm not telling you anything you don't already know, is that in all sorts of ways you're obliged to take on the whole person. And therefore, you do need to, in fact, to be reasonably attuned to how people are feeling, their emotional side, their mental side, as well as their physical and performance in their job. Role modelling the behaviour that you expect of others is very important. And this, I suppose, is probably one of the better strategies that you can consider in a workplace where you think the highest risk comes from the behaviour of the boss or the bosses. I would note that those performing the role of human resource manager in your organisations will be finely tuned into this. It's not an easy thing to tell the managers, the CEO, the senior people in the organisation that it is them that is the problem. But you do need to think about strategies to deal with that. One of which is that if you can get cooperation on everyone in the organisation being obliged to role model behaviour and incorporate that, for example, within how their performance is assessed, then you may have taken a pretty good step towards dealing with the problem. Another area which we don't have a lot of time to talk about is the concept called bystander intervention. This is an area that there's been considerable study in all sorts of psychology literature, which is now being translated into the workplace. It is about understanding where other people in the organisation that work alongside people who are being harassed or bullied, what are the circumstances around which they may intervene to, in fact, assist and get a resolution before it lands in your in-basket, where you have to deal with it after it's bubbled to the surface. I'd encourage you to have a look at the Human Rights and Equal Opportunity Commission report on this and any other literature that you can access on the subject of bystander interventions as applied to the workplace. Okay, moving on to the next phase of this webinar. And I should say is that if you do have any questions, please log them on, and Asa will remind me to answer those questions either at the end of the session or as we go along at a appropriate juncture. Conflict resolution. With all of the best intentions, programs, strategies, policies in place, you may still inevitably face a complaint of workplace bullying and harassment. The threshold for complaint, certainly under the legislation, the laws of Australia that I very quickly outlined before, are in fact quite low. And there's probably good public policy reasons underpinning that to enable people to be able to complain where they are suffering from a workplace harassment and bullying. But nevertheless, it does create a risk which is probably almost impossible to completely eliminate. So therefore, we should spend a bit of time talking about, well, if we do get complaints, what are we going to do with them? Well, there's clearly two options. You can ignore it and hope it goes away, and that used to be the old strategy. Or secondly, you can do something about it. And in fact, there's really no options anymore. The The law says you have to do something about it, so therefore we need to think about what we're going to do. There are various methods that can be applied to resolve bullying and harassment conflicts. Each of the alternate dispute resolution methods listed above, which I've got listed as external resolution, are applied by bodies such as Fair Work Commission, the State Work Cover Authorities, and the Human Rights and Equal Opportunity Commission and anti-discrimination tribunals in each state. That is conciliation, mediation, facilitation, and in some instances arbitration. Of course, there is no correct method. There is an appropriate method for the circumstances of each case. For example, sometimes it is appropriate to engage an external consultant to mediate a dispute or conduct an independent investigation of the situation before the employer decides on a course of action, such as managerial directive. That could be, for example, separating the person who is complained about from someone else to work in another area. It could be disciplinary action. And what I'm experiencing is increasingly, as the clients of mine are engaging external and qualified and expert mediators and investigators to do the preliminary work before they come in, assess what's gone on, report from such investigators, and then apply appropriate resolution methods. Now, the best approach to address the problem is certainly a collaborative problem-solving approach. If you are confident and capable, then this is probably the best method that you can apply internally to resolve a dispute. Often the resolution of the conflict will be taken out of your hand, however, and you may have to answer to the Human Rights Commission, Safe Work agencies, or after 1st of July, the Fair Work Commission. But even if you are called before those regulatory bodies, you receive letters asking for you to attend a conciliation or to respond to a complaint, those regulatory bodies will invariably temper their action and their view of the grievances according to how well you have already addressed the issue internally. So notwithstanding whether you get an external grievance, it is still worth following the matter up internally. Okay. Don't solve one problem while creating another. What I mean by that is complaints must be resolved, but the best way in which you resolve them must include a fair procedure, and it has to be a fair process for all parties. And this means several things. For example, listening to the complaint and taking notes. Pretty simple, seems common sense, but often many employers make the mistake of not listening and jumping to conclusions. Ask questions. Very simple ones I use. Who, what, when, and how. If you get answers to those questions, then you've started off on a pretty good investigation to get the facts. Ask the complainant how they would like the matter resolved. They can't dictate how it's to be resolved, but it's important to know where they are in their own mind about how they see the matter being resolved. Stay impartial. Don't promise complainants anything until you've fully investigated the facts. Be open and frank with the person that is the subject of the complaint. You can't dance around it. Stay impartial. Don't jump to conclusions. Emphasise to all parties confidentiality. Once it comes out in the open, it's very difficult to resolve. Draw your conclusions from the facts and not what you think what might have happened. Having said that, though, you are entitled to believe one party over the other if it comes down to he said, she said, he said. Okay? It's not a forensic police exercise. It's a workplace issue. If it does come down to a very serious allegation of harassment that might constitute assault, for example, then that may be a different matter. But the vast majority is really about conflict. So you can, in fact, balance what people are saying and draw some conclusions. All right, let's start to, I suppose, get to the pointy end of this by looking at, well, there's some important preconditions for you to resolve a conflict. Or might I say is that if you want to successfully resolve conflict, then you should pay attention to three preconditions. There needs to be an opportunity to resolve the matter, and that's all about timing. Working out when is the best time to get the parties together. When is the best time to interview them separately? Where is the best chance, the best place to interview people? Capacity. Capacity is all about the person, the aggrieved person, and the person being complained about, or the various parties involved, is whether they are actually capable themselves of coming together and resolving this conflict, or are they so entrenched and emotional, can they understand how to resolve the matter? Do they understand that even simple things, for example, you may have a workplace where there are a multitude of first-generation migrants, and the conflict may have a racial basis or a language problem. Can you get people to understand each other? And thirdly, volition. There's a phrase you don't hear used often. What that means is really the preparedness. Are people willing? Are they prepared to work together to resolve a conflict? If you can get those three conditions satisfied, then you'll certainly have a greater chance of solving the conflict. Now, the importance of workplace policies. Workplace policies serve three purposes. So in the final part of this webinar, I'd like to point out the importance of them. I assume everyone has written policy indicating the employer's intention to promote harmonious working environments and stamping out harassment and bullying. However, these policies are just empty statements unless you apply them in a manner that produces real results. Firstly, education. The policy educates employees and managers in the standards of behaviour expected in the workplace and provide a broader statement of your values to your customers and broader stakeholders. You can publish them on your websites. Thus, you use policies in recruitment. As you'll know from your own experience, people may be drawn to your organisation because of your values. So, talking about them and publishing them before people are employed, during inductions, and through all of your learning and development activities will educate people to the behaviours that you would expect. Secondly, administratively. Second, up-to-date workplace policies are an indicator of your compliance with regulatory standards and codes. This is one of the things that is very, very important as a basic fundamental where there is no argument. You actually have to have up-to-date workplace policies, written ones, which are compliant. Many of you may, in fact, undertake certification under ISO, Australian standards, or standards that are applicable, quality standards applicable to your industry. You should be familiar with compliance if that's the case. Thirdly, a well-formulated policy will provide a checklist of action where intervention is needed to resolve complaints. That is the remedial action. Very difficult task, and therefore a clear policy checklist will assist you or whoever you get to do the work to work systematically through the steps to investigate, to conciliate, mediate, and finally to resolve incidents of workplace bullying and harassment. All right, well, let's finish it up with a top tip, hopefully a top tip, the role of the employer, and reiterating some of the key points that I've tried to quickly cover in this very short seminar today. Role model appropriate behaviour, I think, is one of the best strategies that you can apply. Promote the organisation's policies, promoting them not just internally, but promoting them externally. Intervene in inappropriate behaviours. Intervene at work, outside of work. This is getting people into the habit of not controlling their behaviour, but checking people's behaviour where it may potentially lead to a serious risk of claims being made against you as employers. Respond and resolve complaints. Difficult task, but you do need to respond and you need to act promptly. Now, there's some simple ones. There's certainly lots more strategies that could be applied. And as I said earlier, the details of the appropriate strategies will depend upon the detail of every particular circumstances. So I'll leave you with those tips, and thank you very much for your attention. And I certainly hope you have success in dealing with this in your own organisations. I'll hand back to you, Asa, and if there's any particular questions, I can answer them.
Yeah, sure, Paul. So we do have a couple of questions from Therese. Now, the first one was, does the proposed opening of B and H jurisdiction to FW mean that employers may potentially face the same claim being raised against them via work cover and FW, same time or consecutively?
Yes. That's a really good question, and the answer is yes. My personal view is that it is the amendments to the Fair Work Act are not needed. And they will, in fact, add an additional layer. So it's not going to be an exclusive jurisdiction. If they had have taken over the jurisdiction, that would have been fine. But certainly one of the risks here is that the employers may, in fact, have to face several grievances coming out of the same set of facts. Unfortunately, that's one of the pitfalls or problems with this new law.
Mm-hmm.
And the next one?
Okay, so the next one we've got, what are legal ways to deal with vexatious complaints in the adverse action climate?
Okay, another good question. Very difficult. Certainly the laws, the Australian laws are designed around, I suppose, excluding frivolous or vexatious claims, and that's specifically stated in the adverse actions provisions under the Fair Work Act. In practice, however, it is very rare that any of the regulatory authorities, and certainly not the Federal Court or the Federal Magistrates Court who deals with those matters, are very, very reluctant to strike out a claim and will usually defer on allowing claims to go ahead and letting the person have their day in court. So it certainly is no strategy that I can tell you that would enable you to be able to get these things knocked out. However, if you believe they are vexatious, then you ought to raise that. You're certainly not prevented from that, and it may put an additional hurdle where you believe that they are frivolous or vexatious, but the chances of success, unfortunately, are fairly slim.
Okay, great. Now, we do have one more there, Paul,
Sure.
And it's from Therese as well. So I think it's in relation to your top tip.
Okay.
What do you mean intervene in appropriate behaviours outside of work?
Okay. Look, thanks again. That's a good question because it's the subject of probably another workshop or webinar, and that is that the employer's responsibility for the behaviour or conduct of its staff extends beyond the normal 9 to 5 or the physical workplace. There's quite an interesting case which is heading all the way to the High Court. Typically, they're usually sexual salacious cases. You may be aware that employers can be held responsible for the conduct of staff, for example, where they are out on the road working for employers with clients in the clients' workplaces. Certainly, if they're attending conferences, you could be still held accountable. The behaviour of people at conferences, Christmas parties, all those sorts of things, there's multiple cases where employers are being held accountable for people's behaviour, and we've had people dismissed, and we've also had people who have been received workers' compensation for events that have occurred outside of the normal 9 to 5. So addressing your policies in a way which brings employees' attention that they are still acting on behalf of the employer as an employee outside of the workplace is worth doing.
Now we have a question from James.
Okay.
How do you measure the seriousness when allegations seem trivial?
Yes. Okay. Well, there's no magic solution here, James. I think under the current climate, you effectively have to take all claims seriously in the first instance, at least in accepting and documenting a claim before you might dismiss it as being trivial. My experience is that you've got to try and develop a sixth sense for these sorts of things. And knowing your managers, knowing your staff, and knowing the circumstances around the relationships in the workplace can be a two-edged sword. It both gives you an insight into complainants and complained about, but you also need to ensure that that doesn't necessarily prejudice you from considering claims seriously. So unfortunately, James, I can't give you a good formula about that, except to say my tip is that I think you should, in fact, in the current climate, take all claims seriously in the first instance.
Okay, so Paul, that is all the questions that have come through so far.
Okay, great. As I said, look, on the slides, if you wanted to ask any questions or continue the discussion, I'm happy to do. Send me an email and we can talk about those. But otherwise, thanks for the opportunity to presenting today.
Thanks, Paul, and thanks everyone for joining today's webinar. On behalf of Redback, I would like to thank Paul for his time today and wonderful insights into bullying and harassment. If anyone from Redback on how to host your own webinars, please feel free to let us know in the exit survey, which you will now be redirected to. Enjoy the rest of your day.